Hey everyone, welcome back to the channel. Today we're talking about something that affects more families than you might expect, challenging a will. Maybe you've been left out, maybe something feels off, or maybe you just want to understand your rights. Whatever your situation, this video will break down exactly when you can challenge a will in the UK, what the legal grounds are, and how the process works. Let's get started. Why people challenge wills. Will disputes are becoming more common every year. Families are more complex, people live longer, and sadly, disagreements often arise after someone passes away. According to legal experts, people challenge wills for a few main reasons. They believe the will is invalid, they think someone influenced the person who made it, or they feel they weren't given reasonable financial provision. But here's the key point, you can't challenge a will just because you don't like what it says. The law only allows challenges on specific grounds. So let's break those down. Legal grounds to challenge a will. 1. Lack of testamentary capacity. This is one of the most common reasons wills are challenged. The person making the will, called the testator, must have understood what they were doing at the time the will was created. That means they needed to understand what a will is, what property they own, who might expect to inherit, the consequences of their decisions. If the testator had dementia, severe mental illness, or was heavily medicated, their capacity may be questioned. Medical records, witness statements, and solicitor notes often become crucial evidence. 2. Undue influence. This is when someone pressures, manipulates, or coerces the testator into making or changing a will. It's not enough to show the person was persuasive, you must show they overpowered the testator's free will. Examples might include a new partner isolating an elderly person, a caregiver threatening to withdraw support, a family member controlling access to finances or visitors. Undue influence is notoriously hard to prove, but it's a valid legal ground. 3. Lack of proper formalities. In the UK, a will must follow strict rules to be valid. According to legal guidance, a valid will must be in writing, signed by the testator, witnessed by 2 independent witnesses who are present at the same time. If any of these steps were skipped or done incorrectly, the will may be invalid. If a beneficiary acts as a witness, this does not make the will invalid if other formalities were correctly observed. However, the beneficiary would lose their gifts. Fraud or forgery. This is one of the most serious grounds for challenging a will. Fraud can include a forged signature, pages being swapped, someone tricking the testator into signing a document, a will being destroyed or replaced. If fraud is proven, the will is invalid. Unlike other claims, fraud has no strict time limit because of its seriousness. However, it is best to act immediately, ideally before probate is granted, as contesting after probate, when assets have been distributed, becomes much harder and costlier. 5. Lack of knowledge and approval. Even if the will was signed correctly, the testator must have understood and approved its contents. This becomes an issue when the testator was blind or illiterate. They didn't speak the language the will was written in. They were extremely frail or medicated. Someone else prepared the will without explanation. If there's doubt the testator knew what they were signing, the will can be challenged. 6. Inheritance Act 1975 claims. Now, this one is different. Even if the will is completely valid, certain people can still challenge it if they weren't left reasonable financial provision. Under the Inheritance, Provision for Family and Dependents Act 1975, eligible people include spouses and civil partners, former spouses, if not remarried, children, people treated as children of the family, anyone financially dependent on the deceased. This type of claim doesn't argue the will is invalid, it argues the distribution is unfair. How to challenge a will. So, if you believe you have grounds to challenge a will, what happens next? Here's the typical process. Step 1. Enter a caveat. A caveat stops the probate process, meaning the estate can't be distributed, while the dispute is investigated. This is usually the first step and lasts 6 months, with the option to extend it. Step 2. Get legal advice. Will disputes are complex, emotional, and often expensive. Solicitors can help you understand whether your claim is strong and what evidence you'll need. Many cases settle out of court, but you'll want professional guidance from the start. Step 3. Gather evidence. Depending on the grounds, evidence might include medical records, emails or letters, witness statements, solicitor notes, financial documents, handwriting analysis. The stronger your evidence, the more likely the case will settle without going to court. Step 4. Mediation or negotiation. Most will disputes are resolved through mediation. It's faster, cheaper, and less stressful than court. A neutral mediator helps both sides reach an agreement. Step 5. Court proceedings, if necessary. If no agreement is reached, the case may go to the court. This is usually the last resort because it can take months or even years, and costs can be significant. Time limits. Different types of challenges have different time limits. Here are the key ones. Inheritance Act claims, usually within 6 months of the grant of probate. Challenges based on fraud, no time limit. Challenges to the validity of a will, ideally before probate is granted. Claims against executors. Varies depending on the issue. If you think you have a claim, it's best to act quickly. What happens if the will is invalid? If a will is successfully challenged and declared invalid, one of two things happens. 1. An earlier valid will takes effect, if one exists. 2. If there's no earlier will, the estate is distributed under the rules of intestacy, which follow a strict order of relatives. This is why it's important to consider whether challenging the will actually lead to a better outcome. Final thoughts. Challenging a will is never easy. It can be emotionally draining and legally complex. But if you believe something isn't right, whether it's undue influence, lack of capacity, or unfair provision, the law gives you options. Just remember, get advice early, gather evidence, and understand the potential outcomes. Thanks for watching. If you found this video helpful, hit like, subscribe, and drop your questions in the comments. And if you want more videos on wills, probate, or family law, let me know, I'm happy to cover them.